Start. The appellants are lady teachers in primary schools in the state of Bihar. Full stop. On their request, comma, they were transferred to the places where their husbands were posted by District Education Establishment Committee. Full stop. The respondents number 4 to 18 were displaced by the appellants, challenged the validity of transfer order before the High Court by means of a writ petition under Article 226 of the Constitution. Full stop. The High Court, by its order dated 8/2/1989, set aside the transfer order with a direction to the authorities for reposting the respondents to the places from where they had been transferred. Full stop. Para. After hearing learned counsel for the parties and having considered the facts and circumstances of the case, we are of the opinion that the High Court committed serious error in transferring with the transfer order of primary school teachers. Full stop. The District Education Establishment Committee had no jurisdiction to transfer the primary school teachers on their request. Full stop. There is no dispute that the District Education Establishment Committee is competent to transfer primary school teachers from one place to other place, but merely because such transfer was made on the request of teachers. Full stop. The committee is divested of its jurisdiction. Full stop. The Director of Primary Education had issued direction that lady teachers posted in distant or rural areas may be accommodated to the place of their request to avoid hardship to them. Full stop. This direction is reasonable, and District Education Establishment Committee followed the same principle in transferring the appellants on their requests to avoid hardship which was being caused to them. Full stop. The respondents challenged the validity of transfer before the High Court on another ground also, that primary school teachers posted in the urban areas were not liable to be transferred from urban to rural areas. Full stop. The High Court did not interfere with the order of transfer on this ground. It held that the transfer order was without jurisdiction, as the same had been made on the appellant's requests with a view to accommodate them. Full stop. We fail to appreciate the reasoning recorded by the High Court. Full stop. If the competent authority issued transfer order with a view to accommodate a public servant to avoid hardship, the same cannot and should not be interfered by the court merely because the transfer order was passed on the requests of the employees concerned. Full stop. The respondents have continued to be posted at their respective places for the last several years. Full stop. They have no vested right to remain posted at one place. Full stop. Since they hold transferable posts, they are liable to be transferred from one place to the other. Full stop. The transfer order had been issued by the competent authority, which did not violate any mandatory rule, therefore, the High Court had no jurisdiction to interfere with the transfer order. Full stop. Para. In our opinion, the court should not interfere with a transfer order which is made in public interest and for administrative reasons unless the transfer order is made in violation of any mandatory statutory rule or on the ground of malafide. Full stop. A government servant holding a transferable post had no vested right to remain posted at one place or the other, he is liable to be transferred from one place to the other, full stop. The transfer order issued by the competent authority does not violate any of his legal rights, full stop. Even if a transfer order is passed in violation of executive instructions or orders, comma, the court ordinarily should not interfere with the orders, full stop, over.